7 days of trial, 19 witnesses, and the state of Arizona just rested its case against Lori Vallow Daybell, the so-called doomsday mom, also resting her case without presenting any evidence. But there's a twist. She didn't rest in front of the jury. Is there a chance Vallow Daybell changes her mind and testifies to finish her defense against the charge of murder conspiracy in the death of her fourth husband, Charles Vallow? I'm Justin Lum, and we are on the record. Well, after 7 days, we have closing arguments set for Monday morning at 10:30 a.m. Lori Vallow Daybell resting her case, but not 110% resting her case. We are going to see what happens tomorrow as the court goes over jury instructions, but there is that small window where she could change her mind and testify because she just didn't rest in front of the jury. But she has no witnesses to call, and so I assume no evidence.
Yeah, would you expect anything less from this case? One last curveball,
Yeah.
just one last little curveball. Everything we've been waiting on, would she or wouldn't she? And now we're still left wondering, although, again, like you said, we're pretty certain she's not going to testify. And after today's testimony, why would you?
After Nate Duncan surprises us all as the last witness when we thought there were two more, I guess, the state doesn't have to follow their exact list of witnesses. They don't have to get through all 21. And obviously, Prosecutor Trina Kaye felt that Duncan was going to seal the deal. And we will see what happens when a verdict comes out, and if that was definitely an X factor. Nate Duncan, under the weather the past couple days, comes in today and really answers yes or no and correct to questions about all of the text messages and the evidence regarding Chad Daybell, Lori Vallow, and Alex Cox, and we'll get to that in a little bit. But after the state rested, I think it was interesting that Lori called a Hail Mary just to see if Judge Boreski would just, give me an acquittal, and then, she wouldn't have to answer the question about presenting evidence. But maybe that's just what any public defender would do, any defense attorney. Let's listen to this soundbite where Lori says there's not enough evidence in the case.
Your Honor, I'd like to address a Rule 20 motion first.
Go ahead.
Okay. The state has failed to show substantial evidence for count 1, conspiracy to commit first-degree premeditated murder. The state has provided no evidence that I agreed with another person that any one of us would engage in certain conduct that I intended to promote or assist in this premeditated murder. Crime premeditated murder requires the state to establish a person caused the death of another with premeditation. The lack of evidence to show any evidence of a conspiracy to commit murder, there was no plan to murder Charles. No evidence has showed that, in fact, evidence suggested self-defense on the part of Alex. So I would like to put that on the record.
All right. State, want to put a response on the record?
Yes, Your Honor. Looking at the evidence in the light most favorable to the state, there's sufficient evidence based upon everything from the iCloud messages from between Alex, the defendant, and others leading up to July 11th of 2019, that Alex Cox was invited over by this defendant, knowing that they were going to be having an intervention and knowing when Charles would be there and bringing a handgun over with him. The timelines on July 11th of the killing of Charles Vallow and the fact that the number of shots and the physical evidence at the scene, the statements by the defendant to Detective N-Clan that she took Charles Vallow's phone and would not give it back to him, the motive for money, and especially the defendant's motive for having an affair with Chad Daybell. All of those looking at together in the light most favorable to the state, the defendant or the jury could find the defendant guilty of conspiracy to commit first-degree murder.
Last word. Do you want to add anything?
No, Your Honor.
All right. The standard is whether or not a reasonable juror whether or not there's substantial evidence for a reasonable juror to find the defendant guilty. The court does find that there is substantial evidence that a reasonable juror could find the defendant guilty. The court will further add that the jurors are the ones who judge the credibility of the witnesses, and it's ordered denying the Rule 20 motion. Are you going to present evidence tomorrow, either through witnesses or through your own testimony?
No, Your Honor, the defense will rest.
So obviously Judge Boreski believes that this is a no-brainer as far as at least putting it in front of the jury. And remember, we have 14 jurors, 12 will be finalized. There were some critics and the experts we talked to every day that felt like, oh, this is a little strange and a little concerning that there's only 2 alternates. But so far, in a quick trial, 7 days, we got 14, and we'll see after closing arguments what they will decide as far as who's the final 12. But just a lot of evidence that we saw today. I think it is perfect timing for the state to rest their case.
Yeah, you have to wonder if this was the plan all along, or was this something that Trina K kind of figured throughout the day? Like, look, this guy's doing exactly what I need him to do and present what I need him to present. She controlled a lot of the testimony in such that she was asking a lot of questions and getting Detective Duncan to really say yes, no, whatever. And you wonder whether she or her team was monitoring the jury and felt like, look, I don't need to call up my last 2 detectives. He's hammering home what I need him to hammer home. This is what the jury needs to hear. This is our case. We're done. Good luck, Lori.
Trina says there's no self-defense. There's a $1 million life insurance policy that Lori thought that she was going to cash in on. And then there's this romance. We finally got to see that today. We hadn't heard much about Chad Daybell. You heard about Chad Daybell in opening statements. The jury doesn't know he's on death row for killing Lori's kids, as Lori's also convicted of killing her 2 youngest kids, JJ and Tylee. But the love affair was presented. The story of James and Elena was brought in. They didn't read the whole thing, but obviously people could get the picture. A lot of people watching our coverage and in the chat are just kind of like, cringing because they remember this from the Idaho trial, the loin-to-loin, cheek-to-cheek reference, and how Chad and Lori were basically talking to each other every day, giving each other multiple reminders of their love for each other. Meanwhile, Lori Vallow is married to Charles Vallow. He's finding out about this affair, and the jury's now seeing her go after witnesses and make Charles look like a bad guy for talking to other women. So this tone has been set. Let's hear Trina's direct exam on Nate Duncan regarding her not getting the life insurance.
And so we learned that Lori received a email indicating she was not the beneficiary, and later she had a phone conversation.
Correct.
Does this one appear to be sort of the earlier one because it references, I just got the letter from the insurance company saying that I'm not the beneficiary. It's a spear through my heart. Who do you think he changed it to? Brandon or probably Kay? He left nothing for JJ.
Correct.
Did that conversation go on? Wow, that's terrible. There's no way to find out.
It did.
And did Lori then tell Chad, I might be able to see when I get his computer on Sunday, I could check the emails sent to the insurance company. It will show change of beneficiary. He must have done it recently.
Correct.
So we had seen, in fact, photos what appeared to be from a computer that were sent to Chad Daybell, correct?
Correct.
Showing that beneficiary change.
Yes.
So does that seem to match with, again, what Lori's telling Chad here about finding out who got that money?
It does.
Does Chad then say, it seems you would have to agree to change, maybe the name was forged, you should have a good paper trail to prove it, right?
Correct.
So he's trying to help her figure out how to get that money.
Now, just listening to that exchange, we were talking about how that may have been an opportunity for Lori Vallow Daybell to object upon speculation on behalf of Trina K.
Right. You can't get a witness to interpret what somebody else might have been thinking or what they might have been feeling. We noticed it right away. Like that was a great opportunity for her to object and say speculation. She didn't. And then I don't know if prosecutor.
It wasn't a question. It was a statement, basically.
And
Trina got away with it.
She got away with it and just kept going. And you can go back and look at this entire trial, and there were many instances like that where even those of us who are not attorneys could pick up on, like, even if you think you're going to get overruled, right? That's an opportunity to stop the pacing, stop it, let the jury see that you're paying attention.
So, we're football guys, but I liken it to you're just running the same run play and you're just going up the gut, first down. At some point, you got to do something. You've got to, object, do something in your game plan to basically stop them stuff them, and Lori has not. She's objected to relevance a couple times. And judge just doesn't even say overruled. He just moves on, lets the evidence be admitted. So she's still learning as she goes. She will learn a lot for her next trial regarding Brandon Boudreaux and that shooting. But in this case, like you have been saying, Trina K has been in cruise control. And when she's objecting to Lori's cross-exam, it's mainly sustained, like a lot of the time, left and right. And we got to see that cross-examination where Lori's basically almost like disrespectful to the investigation, to Chandler's investigation, saying that Nate Duncan had not collected Alex's phone. She had not talked to her family members, like her mom and Summer Shiflett, and basically calling him the case agent and saying that he had not done enough by her questioning.
Almost implying they were a little sloppy in their investigation at times. I thought hammering home what for an average person would be great points. You've just presented all of these text messages between all of these people, but you never spoke to any of these people to find out more about what these messages mean. Fair point. Now, he came back and said, look, none of those people were there on the morning of July 11th.
Yeah,
of the
they weren't
shooting.
relevant.
That's my case. So, I mean, he had a great answer, but in my opinion, probably her best cross of the whole trial.
Yeah. It was still, as far as the tone and how she, just the confidence was there, but that may not matter because, like, does it make sense? Do the questions make sense to the juror? And she even, to the jury, she even brings up the bat, DNA being tested or not, and how Charles' DNA, she says, could that have done something? Could have meant something to your case? And I thought this was important to say that you had all these people in the house. You had Tylee bring out the bat. It was her bat. Her hands are on it. Alex's hands are on it. You guys all lived together at some point, including Charles. This would just be proof, testing it for Charles' DNA and even it confirming a match that he's touched it at some point. It doesn't mean he took the bat and whacked Alex in the head with it.
Right.
And then again, there was no blood evidence that they could see on the bat. And then this is where her comment gets stricken from the record because she says, well, what if Charles just pulled that bat from Tylee, like Tylee had said in her statement to police? And Trina was not having it.
Right. Yeah, she, this is where that slippery slope of what can be admitted, what can't. Trina was quick. She knows her stuff. She's had 2.5 years to put this case together, more than that. So she knew, I think she anticipated a lot of what we heard and was ready to make sure it did not get in the jury's ears, that it was stricken from the record. I don't think there was much that surprised her.
Bottom line, Tylee, Alex, anything from them is hearsay. That was ruled on before trial. So, but this was, I think, the best exchange or most interesting and fascinating for the cross-exam about Nephi, where Lori basically tries to educate Nate Duncan on the Book of Mormon and how what he said to the jury was basically, very, very influential, and she attacks him in this cross-exam. Let's listen.
Yeah, 4 different prophets in the Book of Mormon that are Nephi. Are you aware of that?
No.
Okay. So isn't it true that you really have no idea what I was referring to when I referenced Nephi in my text message?
I can only go off of what I see. I can't tell you what you're thinking or what you're trying to relay there, but based on my knowledge and based on talking to people about who is Nephi, that is a story that came up consistently.
You relayed to the jury that it was in order to kill. You relayed to the jury.
I said that the story was the same story and similar to Adam told.
Okay, and you said it earlier that was in order to kill. That I referenced Nephi. I will be like Nephi and you will be like Nephi. To the jury here today.
Ask a question. That's a statement, not a question.
Now, Duncan makes it clear that this wasn't an explanation to the jury, but what he had heard from Adam Cox, who was very key as a witness, Lori's brother, and talking about this whole Nephi Laban story. But I think when you talk about all these versions of the Book of Mormon and versions of Nephi, I think the jury they may not be in that religion and understand, but do they just think that she's crazy? I'm just wondering what the jury's thinking at that point as she goes off on this tangent.
Well, we know that, look, there are a number of religions in the world, and we know at this point that Lori and Chad, Lori specifically, Alex as well, that they were all very religious people. But I think the common person, the average person, should be able to deduct that, look, no matter what your religion is, nothing in any of these religions should be enough to kill someone, right? So even if you don't quite understand the inner workings of the LDS faith and the Book of Mormon, at the end of the day, as a juror, you're probably taking away and should take away, no matter what it says, how many books of scripture, that it doesn't justify this type of crime.
Yeah.
And I think that in and of itself is enough, at least for Trina K, to say, look, we're going to talk about it. You're going to hear these terms, and you're going to obviously see them explain what these terms meant in their messages. But at the end of the day, none of it justifies what Charles got.
And we're not going to teach you about the Book of Mormon and who's who and why Nephi is important. But I do get why Lori is saying, or trying to make it look like, Nate Duncan, you are using that against me and saying that the Nephi story was a directive to kill, and I didn't say that. She's defending herself. She's trying to do whatever she can do in cross-examination. So besides that, here we are. Maybe there's a chance that she decides to testify. I don't think so, but we're getting ready for closing arguments now Monday morning, and really less than 10 days, we could have a verdict. I think that's pretty amazing.
I mean, here we are. They said 6 weeks. We're 2 weeks in. We're not even finished with the second week, and both sides have rested, and we expect closing arguments to begin 10:30 Monday morning, and we know that Trina has plenty to say in her closing. Lori didn't indicate how much she has to say, but I would imagine she's going to have something.
Yeah.
Clearly not as much as Trina K does. And then we wait to see how long it takes the jury.
This is how Lori can do her testimony in closing arguments without having to be questioned by Trina K. Trina's going to go for an hour plus. We know that. She went long in her opening statement. She's going to try to bring it home. Lori said she's not going to go that long. She has no real defense at all. So, yeah, I know that window is open. But, yeah, it would just make sense for her to do basically her testimony through closing arguments. So tomorrow, jury instructions will be reviewed. I don't expect it to be that intricate with it just being one charge, conspiracy to commit first-degree murder. But for those of you wondering, we will have coverage of what goes down at around 10:45 a.m. In court. Jury will not report until Monday. But, yeah, this is key. The jury has to follow these instructions to come to a verdict, and we'll have coverage of that. We'll see you soon on The Record.